have a better medical system.
All right. Mr. Keene.
Well, Your Honor, first, acknowledge Dispatcher Lotomire.
Right here, Mr. Keene starts with emphasis. Mart move in court. Jurors, judges, and even the public latch on to compassion. But notice, he's already setting up a balancing act between sympathy for the victim and mercy for Starky. Classic defense. Strategy.
Myers' statement, it's powerful and sad, and no matter what you decide today, unfortunately, we can't go back to that time. Mr. Starky can't go back to it and undo it. And I'm sure that, I presume the deputy dispatcher appreciates the support by many members of the local law enforcement, because in a department the size of Burnett County, that's a fair share of the number of officers who could be on the street. So now moving to a little to the fact of the matter here, but I wanted to acknowledge that first. Not going to deny that it's a serious offense. Dispatcher Lotomire has had a change in her career. I read her statement talking about losing her ability to golf. And to say that isn't a severe and a lifetime consequence would be, trying to make a mockery of things today. And I am not going to do that. And I certainly don't agree with the idea that, yes, law enforcement is by nature a dangerous job, because law enforcement officers are called to deal with people when things are at their worst. And in a correctional setting, the correctional deputies are there for people who have either been convicted or being charged with criminal acts in the community that often involve violence and or substance abuse and mental health issues. That said, I would never try and say that's like...
This is the big pivot. Keene knows the entire case boils down to one question. What do we do with Starky? Prison, probation, or treatment? Viewers, what do you think? Should someone like Starky get help or hard time?
A mitigating factor, because, well, that's part of their job, because, if we believe that, then trying to find anyone to be a correctional officer if they don't feel support is going to be harder than it already is. But the question you have, and the one
Notice how Keene walks a tightrope here. He's not claiming insanity because that bar is way too high, but he's hinting at enough mental instability to soften the judge's stance. It's a legal gray zone, and Starky lives right in it.
Thought of, and the one the DA has thought of, is what should happen to Mr. Starky from here on out. And if you look at his record from 2021, February 2021, so we're looking at a little over a 4-year period. We're looking at a time in Mr. Starky's life where he's been, kicked out of his home, homeless for part of it, wandering around, in jail most of that time. The last time he was out of jail, I represented him on the probation revocation hearing where he got out. He was put in a hotel for a couple days. And unfortunately for him, trying to get assistance and getting back to housing, because he'd been in custody so long, it was hard to do. And he wasn't able to avail himself of Burnett County's ADRC service because prior to incarceration, his last residence was another county and he'd have to apply there. So I'm not going to argue for straight probation either, because I don't think that the court would treat that seriously. My issue is that, because I've seen this here, with the DA's recommendation and in Sawyer County, one of the issues we have is we have mental health care issues. I'm not talking just about TBI, because the DAs point out that for just TBI, you'd have a longer history or it wouldn't happen at all. But there's certainly some mental health issues that Mr. Starky's been facing, and something obviously has increased them. But over the past several years, I mean, he had several competency reports because 3 different attorneys, 3 different counties thought something was up. And the competency barrier is fairly low. It's just whether he understands the charges. And then, if you're looking at, mental defect or illness, the standard for that is a fairly tough road to meet. He's in between, I would say. Not in between those, but in between a regular functioning person and someone whose mental illnesses are such that a mental defect defense would be in order. If you look at what's happened over the past 4 years, the vast majority of time he's been in jail. When he's been out, he hasn't really had much for services or time. And, his relationship with his mother was, damaged, obviously, for the Eau Claire case, and she chose not to participate in this hearing. So the state's effort here is to suggest that prison is the place where you can get services. And I think we're sort of doing correction officers, along with Mr. Starky, a disservice because we're trying to move along.
This is the gut punch moment. The victim's suffering doesn't expire. That contrast temporary prison time versus permanent injuries, exactly what judges weigh when deciding punishment. Heavy stuff.
Mental health services, you're using prison as a place to provide services that are probably more appropriate in other locations. Because if he didn't have some of these charges, I mean, there'd probably be civil commitments and other items that would also be appropriate. Because there you have, behavioral control issues, and then although he did not express remorse it appeared to express remorse in the PSI, he has expressed it other times when talking to officers. He's expressed that in court. He's expressed that in other situations. So I don't think characterizing him as a remorseless man is there. But, Mr. Starky's a man whose mood changes because you're talking about being cooperative some days, not so cooperative other days. Your impression of him probably depends on whether you see him on a good day or a bad day. So I think when you look at the rehabilitative needs, I don't think that a prison sentence is necessarily going to accomplish that because Mr. Starky has been in jail for most of the past 4 years, bouncing back and forth. And then when he's out on the streets, he's hasn't had a lot of the services. The PSI said that he hadn't had really much for mental health care in the past 4 years. So the question is how to deal with it. And I think one way to deal with it would be in 24 CF 109, I would suggest a sentence of time served, which according to the DA was 338 days, be appropriate instead of the 1 year in jail. And that in 24 CF 91, I would suggest a consecutive sentence with probation and a period of confinement as a condition of probation of 60 to 90 days from today for a specific purpose. So probation can identify places for Mr. Starky to receive, get some evaluations, mental health evaluations, whether he needs a inpatient stay at a mental health facility or some other resource, to allow time for that to happen. And because again, the thing that's startling to me is when I look at it, other than the harm to Deputy Lotomire, which I'm not going to at any point minimize, because that's the worst consequence of the case, because regardless of what you decide, Mr. Starky will presumably get out of jail or prison. But unfortunately for Deputy Lotomire, that's, lifetime consequences. But in terms of Mr. Starky, like the last time he got out, he was on a street hotel for a few days. There's times he's bounced out. He has, 2023, he's kicked out of his residence. He's a man who, before he started getting in jail, had been getting services through Inclusa, and he'd had a representative payee and other things. And I think if we pursue prison at this stage, we're just setting him up, okay, go to prison, and then...
This is fascinating. Keene basically argues that prison is a dumping ground for mental health cases. And honestly, he's not wrong. The U.S. prison system is the largest mental health provider in the country, but it's underfunded, understaffed, and overwhelmed. Do you think that's justice or failure?
When you come back out, you're the same person. Mr. Starky's, through the conduct, through the, there were four competency reports sought, and 3 different attorneys had some of the same questions. Mr. Starky's talked about someone taking his word fines and a lot of other things that indicate some potential, and someone frauding his name and committing crimes. So there are mental health issues that, frankly, I don't believe have been diagnosed because Mr. Starky has been in county jails for most of the past 4 years. And I think when you're dealing with rehabilitative needs, the way to get rehabilitative needs for someone with mental health issues is to get them diagnosed, because we don't know what medications may be appropriate, because Mr. Starky's access to mental health in the past 4 years has been spotty at best and limited to what is offered in county jails. And another thing with the conditional jail is that during that time, the county, if they believe that if probation is not able to, work on getting Mr. Starky some inpatient treatment or intensive outpatient, whatever mental health provider recommends, because that's certainly not my role, then that would allow the county to file for a potential civil commitment so that Mr. Starky could get mental help one way or another, because somebody shows potential danger to the community, versus just going straight to we're going to use prison to warehouse him for a period of time and then hope that when he gets out, he's close, he may be close to the same boat. Mr. Starky does have some tools. Because he did qualify for SSI. He had a representative payee. He does need some time to get those services set back up, because since he's been in custody for so long, you have to start from scratch on applications. And I think the better way to focus on the rehabilitative needs and the protection of the community is to get focus on a program that gets Mr. Starky mental health in the shorter order than, go to prison, go to classification, because they recommend 2 years. So, you're looking at almost half a year before civil services, and we know that the prisons aren't
Now the spotlight shifts. Starky himself can speak. This is high stakes. Does he show remorse? Does he sound stable? Sometimes a single statement can sway a judge more than hours of lawyer arguments. Let's see how he handles it.
panacea either, because the prisons talk about shortages in services, staffing for mental health, staffing for their own safety. So in essence, we're the DA's recommendation transfers the burden to the prison system, which, useful for Burnett County, but doesn't really do anything more in terms of rehabilitative needs than the proposal we would suggest is, to recommend that time served in 24 CF 109, which is the 338 days, 24 CF 91, consecutive, 3 years of probation with I'd say 60 and 90 days of conditional jail to allow for probation to try and figure out, if there are services they can get them into through Department of Corrections, whether it's a halfway house or some other supervised environment. And if the needs are more severe, then the county could, through Corporation Council, consider, a mental health evaluation or hold versus just hoping that we make the problem go away by prison. Now, regarding protection of the community, and I will include the jail staff and I'll include the correctional officers in the Wisconsin State Prison System, focusing on the mental health treatment to deal with whatever Mr. Starky's issues may be that go beyond TBI would probably do more to protect the community than just, go to prison for a few years and hope that they can provide you resources you haven't been provided in the past 4 years. Because Mr. Starky is, like I said, he hasn't had them for the past 4 years. A supervised placement with mental health services would probably do more to protect the community than just make him the problem of the Wisconsin State prison system. So with that in mind, like I said, I'm not suggesting a pure probation. Suggest that the 24 CF 109, I think our argument would be treat that as, use that